Next case set for argument is State of Ohio versus Patrick Shank. It's case number 18CA0107M. Both parties are represented by counsel here this morning, so each will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. Just let me know how long you'd like, and I'll try to keep track of that time for you and let you know as you get close. The court has read the briefs in this matter, and we are prepared to proceed if you would.
Thank you, Your Honor. Good morning. My name is Dave Mack, and
since we do videotape, we would like you to stand at the podium. Thank you, counsel.
And first I want to thank the court for allowing me to proceed to argue today. And as you know, I represent Patrick Shank, and here for basically asking for post-conviction relief. You know, I would suggest that post-conviction relief for any attorney is somewhat complicated, and actually, if you finally realize why I took geometry and actually calculus in high school and college, because there's a lot of derivatives here, a lot to keep track of. And I would suggest to the court the main thing we're looking at today is this is an issue of procedural default, and as to whether or not there was cause and prejudice. But even to get there, and as Judge Collier pointed out, but we disagree, is that do we even have the right to be here? And the main issue in there is whether or not there's a right to counsel and post-conviction relief. And Your Honors, I cited the State versus Martin case, but the Sixth Circuit and the United States Supreme Court and the federal courts have been deciding these cases based on two other cases, Martinez versus Ryan and the Trevino versus Thaler cases. Ohio has basically, based on the facts of the cases that have come up so far, have said Martinez doesn't really apply. But the main issue we look at there is whether or not you have the right to bring the issue in the appeals court as opposed to the post-conviction relief. And Trevino basically qualifies Martinez in saying that if you cannot bring the issue into the appeals process and you necessarily have to bring it for post-conviction relief, that is where the cause, that's where you would have grounds to bring this argument.
Did you want to reserve time, by the way?
Pardon me, Ron?
Did you want to reserve any time?
Maybe a few minutes, 3 minutes.
I'll let you know when you get close to 3 minutes.
Okay, thank you.
Okay, go ahead.
So basically, Your Honor, I suggest that the Sixth Circuit and the appeals court has said they were inclined not to adopt Thaler but Trevino, but they haven't done that yet. And what I've seen, especially in a few cases, such as the Betty Mitchell case that came up in 2018, the facts in those cases have always shown that there was a way to bring the matter before the appeals court. I would suggest in this case, this was evidence that was not presented at trial that should have been, we contend, and therefore it's totally outside the record, and we could not bring that up in the appeal for ineffective assistance of counsel.
Are you talking about the alibi witness?
Yes, Your Honor. And as far as the Rule 26 issues, which we brought up in our affidavits, and we brought that matter forward on a motion to reopen the appeal. That's a real gray area for us. In order to get a post-conviction relief motion, the case law suggests that you have to have some sort of ineffective assistance of counsel at the trial level. And with a outburst of AM being something that would not, the trial counsel wouldn't know that wasn't in there until after, it's a gray area as to where that should be under the post-conviction or under motion to reopen. In any event, arguing the post-conviction today, I would suggest that in order to get over that, you obviously have to show there was cause and in this case for not discovering, quote unquote, the evidence, and then you have to show prejudice. And one of the things that Trevino's stands for is that at the post-conviction level, if the inadvertence or inattention or the malfeasance of counsel is substantial enough, that would bring about cause. Your Honors, I suggest that the actions and inaction, the affirmative inaction of the appellate counsel, Mr. Chizelka, goes way beyond anything reasonable. Normally the courts will say, hey, if the lawyer's not doing something, then it's up to the prisoner or the client to do it. But here in this case, Mr. Chizelka insisted repeatedly that the way to do it was his way, and that was through an appeal. And basically, he told my client to, if you want to get political, do it on your own time. At that point in time, Martinez and Thaler, it was around the same time they were coming out. But the counsel still had the obligation at that time to bring forth a post-conviction motion, and he refused. And in that case, my client relying on that, I think that takes the responsibility away from him. And basically, Your Honor, the evidence that that was going to show, that we were attempting to show, was basically gets down to the heart of the matter. My client was accused of raping a girl over 100 times, basically over a summer. And one of the main focuses of that activity was the beginning of June in 2003. Well, Mr. Huffman's testimony was going to be that that whole month, my client was 160 miles away every day. The court looked at that, the trial court, in our initial motion, and basically said, well, it was handwritten. It was his boss and this and that. I would suggest to the court that that's getting a little too far into the analysis of the evidence. And there was enough there on his face that even if they don't give a hearing at that point, that under Williams and Mitchell, it should not have been dismissed. So here we are, where we have a prisoner who basically has not just sat on his rights, but has been told this is the way to go. And the next analysis, obviously, is was he prejudiced? Your Honor, he was certainly prejudiced. This whole trial was a parade of witnesses saying that this person did this on this date, and under the Brady case, if you State versus Brady, you only need one witness, one juror to be swayed by reasonable doubt in light of that evidence. And I would suggest to the court that this is a case where that certain evidence goes right to the heart of, was this person here to do that? And I would suggest that that evidence was very relevant and probably would have swayed the outcome of the trial. We basically contend, Your Honor, that in situations such as this, you can't place that responsibility on Mr. Shank. And even once Mr. Chizelka went beyond the year, and the law changed right around then, so the post-conviction was 6 months, then a year. But once the damage is done there, there's no going back. And any further delays, as long as it was not totally seated on the rights, the delay that came in this case was still reasonable. Basically, Mr. Chizelka, as we know, is no longer practicing right now for the very same things he did to another client, he did to my client. My client had to scramble to try and find someone to figure out what to do from here, and that's when he asked Attorney Stanley and myself to help him out. And like I said, Your Honor, post-conviction cases can be a little bit complicated and especially hard to understand. Mr. Chizelka, brought himself and purported himself to be the expert and to let him do his thing. we ended up trying to do our thing, and it did take a while, but now, several years later, you know, I think even though because of the fact that it is, time has gone by, the fact that the procedural default in the trial and in the post-conviction process was substantial, was also done when my client had a right to counsel based on the Trevino case. I think that the harm...
What is the Trevino case again?
That is Trevino versus Taylor. It was 135 Supreme Court, page 911, 2013 case, and it qualified these type of cases under Martinez, and stating that when there is no possibility that the matter can be brought in an appeal, then that's where this narrow exception of Coleman would apply.
Counsel, I'm just wondering because I'm not seeing it in your brief.
Actually, Your Honor, I found this after. I found this case after. It's.
You're supposed to file a motion for supplemental authority because the other side won't know what you're talking about.
Right.
So that's why I was trying to figure out what you were talking
Okay.
about. Because I did not see this and I don't remember reading that.
Okay, I apologize. No, it was.
The thing is, I haven't read Trevino, but the thing is, obviously, if it can't be raised on direct appeal, it's grounds for post-conviction relief. But the whole point is a matter of, you know, whether it's fair or not. You know, Ohio and United States case law says you don't have a right to an attorney in post-conviction relief. And so your attorney messes up, and how do you remedy that then?
Well, Your Honor, I would suggest that the Supreme Court states that you do have a right.
And this is a Trevino case that you didn't cite?
Yes, Your Honor.
Well, we really can't argue that. It doesn't mean we can't look at whatever the law is, but I'm just saying you really can't argue that this
Right.
morning.
Well, under the Martin case, which I cited in my brief, you know, that deals with newly discovered evidence, and it deals with in that case the witnesses weren't around. The prisoner couldn't find them. He didn't have access to them. He could have, and the court did say he could have gotten one witness statement, but you only get one shot at post-conviction relief, and if it wasn't strong enough, it was reasonable for him to have delayed in getting those. I would suggest that the Martin court does say you do have a right to counsel at the post-conviction, that was discussed in the Martinez case, which obviously I can't discuss right now.
Attorney Scanlon, you have 2 minutes and 47 seconds left. Do you want to reserve that or continue?
I'll reserve it.
Okay. Then we'll give you that time for rebuttal.
Thank you.
You're welcome. Mr. Bellucci, you've got 15 minutes.
Good morning, Your Honors. May it please the Court, I'm Vince Bellucci, and I'm with the Medina County Prosecutor's Office for the appellee of the state of Ohio. Sole assignment of error here obviously has to do with the post-conviction petition, the claim that the trial court abused its discretion when it dismissed Shank's untimely petition without a hearing, and it was very untimely. I'll just start there with the time frames here. And I know Mr. Meck compared post-conviction relief to geometry, but it's really not that complicated, especially when you talk about deadlines. Under the version of 2953-21 that existed in 2015, that's the relevant time, Mr. Shank had 180 days from the day his transcript was filed in his direct appeal to file a post-conviction. That gave him until October 6th, 2015 to file the petition. Shank didn't file his petition until July 11th, 2018. So almost 3 years after the deadline to file it. And Shank didn't even come close to meeting the requirements of 2953-23. That's the statute you go to when you talk about the untimely filed post-conviction petitions. And you start with A1A of that statute. Shank had to show that he was unavoidably prevented from discovery of facts upon which his petition relied. Well, Shank says, my attorney messed up, right? I didn't file a post-conviction petition timely. Ohio courts have consistently held that a defendant's lack of knowledge of the post-conviction process, even due to his attorney's failure to notify him of the process and the relevant timeframes, that doesn't satisfy 2953-23. That's not sufficient to show the defendant was unavoidably prevented from discovering any kind of facts in the case. The Supreme Court of
Counsel,
Ohio...
what about the fact, though, that, I mean, because these are a little different circumstances, he's saying that the attorney actually promised to file the PCR, and he knew what he was doing, he would do it his way.
I mean, I don't think that changes anything. In terms of what he's saying, okay, again, a self-serving affidavit on its own is, I think the appellate courts have found is not really sufficient to do anything. Because you can say anything in a self-serving affidavit, but even if that's true, I don't think that's enough to overcome the really high bar of 2953-23.
That is a horrible position to be in, isn't it? You're in prison, and you have an attorney, and the attorney says, I'm going to take care of this, I'm going to file the PCR. He contacts him repeatedly, and he's like, don't tell me what to do, how to do my job, I know what I'm doing, and then doesn't do it.
And, okay, I mean, he can say that. Again, you know, this is not something that's of record in this case. It's what he's saying now.
Well, but wouldn't that
affidavit.
warrant a hearing, maybe?
I don't think so, because it's something where any defendant can say anything self-serving in an affidavit, first of all. But I think also, like I just said, even due to the failure of his attorneys to notify him of the process, we have law that says that is not that's not satisfying 2953-23, because the question is, are you unavoidably prevented from discovering facts upon which your petition relies? That's not relevant here, frankly. The Supreme Court has held more generally that ignorance of the law when it comes to filing deadlines is also not an excuse for failure to seek timely relief. So the alleged new evidence we have here is Mr. Ed Huffman, his affidavit, and the attached so-called, I guess, calendar. And Mr. Shank claimed that that calendar with Mr. Huffman's handwritten notes on it demonstrated that he was at work, or somehow demonstrated he was at work during at least one of these incidents in July of 2003. Shank provides, this is the big point, no explanation as to why or how Mr. Huffman and this information were not available to him at the time of trial, or at least within the 180-day post-conviction filing period. Shank still doesn't explain why this information couldn't have been discovered through reasonable diligence. In fact, this court has held that trial courts cannot entertain untimely petitions based on facts that the defendant knew at trial. And as the trial court noted, Shank knew his work history, he knew his schedule, he knew Mr. Huffman very well. He's a good friend of his. He was available to Shank at any time during the trial within 180 days of his direct appeal transcript being filed. In terms of the Martin case, the one case that was cited in the brief, that's a second district case, first of all, that's not binding at all on this court, but it is highly distinguishable also. As I mentioned, Mr. Huffman was a close personal friend of Shank's, and Shank provides nothing to suggest he was ever unavailable. There's no evidence of that. In Martin, it was actually undisputed in that case that the petitioner completely lost contact with several alibi witnesses, and that the the petitioner really was unable to get affidavits sooner despite best efforts that he showed. There's no evidence like that here in this case. It's also interesting that as Shank is blaming his appellate counsel for not filing a post-conviction petition, he also says in his affidavit that if he filed a petition, it would have included Mr. Huffman's affidavit, which is interesting because that's an admission by Shank that he did in fact know about Mr. Huffman and his information during the post-conviction period. So he can't have it both ways, essentially. There's also the allegation that the transcript was somehow altered, sort of a conspiracy theory here. The trial court pointed this out. Shank absolutely would have been or should have been aware of that within the time to file his petition. Again, that's not newly discovered evidence that was unavailable to him. Both Shank and his friend, another friend here, Nancy Coe, claimed that the victim made a statement on the stand that the court reporter didn't record. That's essentially the claim here. But neither of them say in their affidavit that they personally heard the victim make this statement, which is interesting. And neither of them say whether the court was even on the record when the statement was made. Also interesting. As Judge Carr noted, it's well established that there's no right to counsel in a post-conviction proceeding. Pennsylvania v. Finley is a seminal Supreme Court case, U.S. Supreme Court case. They say the right to counsel extends to the first appeal of right and no further. And if you don't have the right to counsel, you don't have the right to the effective assistance of counsel. So there is no right to the effective assistance of counsel in a post-conviction proceeding. It doesn't exist. Any claim there had to fail as a matter of law. And then even if Shank somehow satisfied A1A of 2953-23, then there's A1B to deal with. That requires a showing that, but for constitutional error at trial, no reasonable fact finder would have found Mr. Shank guilty. That's another very high bar. And the big argument there again is the ineffective assistance of now trial counsel for not calling Ed Huffman as an alibi witness again. But the Supreme Court of Ohio has clearly held that counsel's decision to call a witness, not call a witness, that's trial strategy. That should not be second-guessed by appeals courts. Shank presents no evidence as to whether his trial court even knew about Mr. Huffman, no evidence as to why or how the decision was made to call him or not call him. And for all the reasons I go into in my brief, it wouldn't be surprising if his trial counsel made that strategic decision not to call Mr. Huffman. First of all, as I said, he's a close personal friend of Mr. Shank. Not only was he his employer back then, he acknowledges he was a friend. He also managed his band back around these times. So there's an interest in the case, there's a bias there. And that's not even considering, you talk about the actual counts of the indictment. 1 and 2 say on or about June 10th, 2003, this happened. 3 to 6 say on or about June 11th through the 19th. So the state didn't have to, we didn't have to prove that any of the rapes occurred exactly on either of those dates. We have a date range, first of all, and then on or about gives you certainly some wiggle room also. So we didn't have to prove exact dates. The state didn't have to prove certainly exact times on these dates that any of this happened. And that's the only time a work schedule would be relevant at all, because he could have done these rapes outside of the normal work hours. That's not hard to sort of conceive.
Of course, these are civil proceedings, the PCRs. Wouldn't that affect his right to counsel as well?
Absolutely. These are, I think it's been phrased as quasi-civil proceedings, which means he doesn't have a right to counsel. Once again, it's been held several times. Just in terms of this schedule where it's written in sort of his name on a date, that doesn't actually say what hours Shank worked on any of those dates. So we don't know when he actually worked. The affidavit for Mr. Huffman does say that in June of 2003, Shank normally would arrive by 7:10 a.m. and he'd leave by 4:15 p.m. Normally, of course, being the operative word there, that would in no way show that Shank was at work during those exact hours on every single weekday in June of 2003. It's not a time clock. It's far from it.
But remind me, were there time sheets attached to the affidavit?
No, there were not, Your Honor. This was a calendar essentially where Mr. Huffman had written Mr. Shank's name under certain dates. There's no saying what hours he was there or wasn't there. He just said in his affidavit he would normally be there from 7:10 to 4:15. But interestingly, he does say that that Shank worked very early on June 11th, 2003, which would actually jibe with the statement of the victim that Shank came home early one day in June of 2003 and raped her. So that's interesting, I think, that it actually implies that Shank left work earlier than normal that day, is what Mr. Huffman is saying. So I thought that was interesting as well. So just to summarize, Mr. Huffman would not have given Shank an alibi for any of his crimes that were committed in June of 2003. Are there any further questions?
Probably not.
Yeah, I would just ask-
58. So.
I'm sorry?
You've got a 1 minute and 58 if you want to continue, you can.
I would just ask that this court affirm the judgment of the trial court and find the court did not abuse its discretion in dismissing this petition. Thank you.
All right, thank you for your argument. Counsel, you will have 2 minutes and 47 seconds for rebuttal.
Thank you. I'll just be very brief addressing counsel's argument regarding the dates and hours and times of work. First of all, I would suggest my client filed a notice of alibi, and I would assume that notice included this evidence, expected evidence that Mr. Shank was working at the time almost 200 miles away. And this whole case, as I said, was a parade of witnesses saying that, that this was a monster just repeatedly raping people. And this one piece of evidence here is the one piece of evidence, even without the notebooks, which I suggest is very detailed and should not, and that would go to the weight of it. Not, I suggest the court should not have started picking it apart. But this one notebook does show, and Mr. Huffman's testimony would show that for the whole month of June, Mr. Shank was working at a school 200 miles away. And on that date that was suggested in there that he worked early, they arrived there at 7 o'clock. He would have had to have worked for less than an hour to get back to Medina by 11 o'clock in order to do what he was accused of doing.
So I just want to make sure with the affidavit, because obviously we'll go over them in great detail, but, so Mr. Huffman swore in his affidavit that every day in June that the appellant was working at a location 250 miles away.
Yes, Your Honor, absolutely. And then we get to the question of, well, did counsel make a decision not to call him? There was never even that issue. Counsel repeatedly told my client they were going to call him. The trial ended, and all of a sudden, it's over. He wasn't called. In this courtroom, my client's looking around going, what's going on? Next thing you know, he's back down in Mansfield. This wasn't a case where it was discussed, should we do it or not. My client was told, this is your guy. We're going to call him, and they just didn't. And we've had no explanation why, and I don't think, counsel would has any explanation. He just failed to call him, and I would suggest that really prejudiced my client, because you only need one juror to give reasonable doubt in this matter. And I think the evidence there at least deserved more consideration and would have done that. Thank you.
Thank you both for your arguments this morning. The court will take the matter under advisement, issue a decision in due course. Once that decision is made, the courts will mail a copy of it to both of you, and the opinions are also posted on the Supreme Court of Ohio's website. So again, I want to thank you both for being here this morning, and